You fought for your green card, and 2026 feels like the rules shifted overnight because benefits, travel, and paperwork are being scrutinized harder than before. If that makes you angry or scared, pause, because some changes are real, some are lender or agency policy, and some are social media noise. I am Fernando, and you are watching US Policy Brief, where we turn complicated immigration updates into clear steps for green card holders and families. Stay until the end, because the last section explains a quiet risk that can hit even longtime residents who think they did everything right. This video is general information, not personal legal advice. So if you have arrests, long trips abroad, or prior immigration issues, consult counsel before acting. Now let's break down what people call rights being taken away, starting with business financing, then public charge fears, then travel and citizenship pressure today. The goal is protection, not panic, because permanent residence is still strong, but you must understand how agencies and databases interpret your decisions in 2026. First, remember a green card is not citizenship, so some programs and privileges can legally be limited even when you pay taxes and follow laws. Second, enforcement in 2026 is more data-driven, meaning CBP, USCIS, and even lenders see patterns faster and question inconsistencies more often than ever before. Third, you can respond with planning. Keep records, avoid avoidable violations, and apply for citizenship when ready, not when you are scared by headlines online. Issue 1 is small business financing, because some lenders are tightening SBA loan eligibility and may require full U.S. citizen ownership for certain programs now. When you hear a March 1st deadline online, treat it as a lender policy date, not a universal law, and verify the product in writing. The practical impact can still be severe, because a single green card owner in the cap table can cause a bank to decline the application. That hits restaurants, trucking companies, software startups, construction firms, and family shops that hire Americans, pay payroll taxes, and depend on affordable capital to grow. If you plan to seek financing, gather your green card, operating agreement, ownership percentages, tax returns, payroll records, and a business plan before applying anywhere. Ask the lender which SBA program it is using, what citizenship rules apply, and whether lawful permanent residents qualify under the underlying federal guidance today. If one bank says no, shop other sources like credit unions, CDFIs, equipment financing, or secured lines, because standards differ widely in 2026 by lender. Do not transfer ownership on paper just to satisfy a rule, because that can create tax problems, partnership disputes, and new immigration questions later on. Instead, document your legitimate business purpose, keep your bookkeeping clean, and build credit relationships so you are not dependent on one program alone ever again. Financing rules feel like rights, but they are often policy choices. So the winning move is early verification and diversified options for business in 2026. Issue 2 is public charge anxiety, because policymakers keep signaling tougher benefit scrutiny for green card applicants, and that message is changing behavior in communities. Public charge rules mainly affect people applying for a green card, not most current lawful permanent residents. But rumors make residents fear any benefit use. The chilling effect is real. Families delay medical care, skip nutrition programs, and avoid help they legally qualify for because they worry about future filings. Here is the fact. Eligibility rules depend on the program, your category, and timing. So one person's risk is not another's risk at all today. If you are adjusting status or consular processing, collect records of benefits used, dates, and eligibility letters, because documentation beats fear and guesswork every time. If you already have a green card, do not assume benefits automatically threaten you, but avoid false claims, because fraud is what creates immigration exposure. A stricter interpretation could also matter later at naturalization, because good moral character includes tax and honesty questions, so keep your paperwork consistent from start. If you are unsure, consult a qualified immigration attorney before you apply for or renew benefits, because correcting mistakes later is much harder in 2026. Also remember, children's programs and emergency care often have different rules, so do not let online posts push you into unsafe decisions for your family. Public charge is about future eligibility, not punishment for being poor, and the best protection is informed planning with documented eligibility and timing right now. Issue 3 is overseas processing, because security vetting and consular capacity can freeze immigrant visa interviews, leaving families stuck in administrative processing for months today. Sometimes applicants complete the interview, then receive a 221G notice, meaning the case is not denied but paused while additional checks or documents are reviewed. This most often impacts people from countries under heightened screening, but the key point is that it can affect lawful applicants who followed rules carefully. Inside the United States, some applicants also report delays when background checks take longer, even though the law does not create a blanket pause domestically. If your case is stalled far beyond normal processing times, attorneys sometimes consider a mandamus lawsuit, which asks a federal court to force action promptly. Mandamus is not a guarantee, and it is not for every case, but it can be a tool when delay becomes unreasonable under law alone. Before considering litigation, document your timeline, save every notice, and ensure you responded to requests for evidence, because courts expect diligence from you first always. Also keep expectations realistic. Some administrative processing is driven by security agencies, and even judges cannot force a shortcut on clearance reviews overnight for everyone. For families, the best defense is preparation. Submit clean documents to NVC, avoid checklist delays, and monitor interview instructions so you are ready on time. These delays feel like rights being taken, but they are often capacity and vetting issues, so plan for time instead of rumors in 2026 now. Issue 4 is the look-back problem. Old arrests and convictions can resurface when you travel, because border systems now display decades of records instantly again. Green card holders sometimes assume a case from 15 or 20 years ago is closed forever, but immigration consequences can remain legally active at entry. A DUI, drug possession, domestic violence allegation, or theft offense can trigger inadmissibility or removability questions, even when you completed probation long ago successfully too. The enforcement environment feels harsher because CBP is using secondary inspection more often, and detention can happen while officers verify court dispositions and records today. If you have any criminal history, do not travel internationally until an immigration attorney reviews the exact statute, plea, and final court outcome in writing. Do not rely on memory, because a dismissed case can still appear, and an officer will ask for certified records, not your story at all. If the record is favorable, carry a packet when you travel, including certified disposition, proof of rehabilitation, and an attorney letter if needed for clarity. If the record is risky, the safer path may be to avoid travel, seek post-conviction relief, or resolve issues before you re-enter the country again. This is not fear-mongering. It is reality that lawful permanent residents have rights, but they can still be questioned at ports of entry now. The solution is preparation, because one old record can turn a routine trip into detention, missed work, and years of stress for families in 2026. Issue 5 is reentry scrutiny, because CBP asks whether you truly live in the United States or use your green card like travel access now. A reentry permit remains useful for long absences, but it is not a magic shield, and officers can still question your residence ties at airports. The more time you spend abroad, the more you must prove your home base is here, through taxes, housing, job ties, and family connections too. Bring a travel folder with lease or mortgage, recent pay stubs, tax transcript, utility bills, and school records, so questions end faster for you today. Do not guess about days outside the United States, because the system tracks exits, and a wrong answer can look like misrepresentation to officers now. If you are unsure, say you need to check your records, because honesty beats speed, and speed is not worth a fraud claim at entry. Secondary inspection is stressful, but it does not mean you are losing status, and most lawful residents are released after questions the same day anyway. Problems start when patterns suggest abandonment, like spending more time abroad than here, having no U.S. address, or filing taxes incorrectly as non-residents sometimes too. If you live abroad for family reasons, document it, keep your U.S. ties active, and consider whether citizenship or another plan fits you long-term. Re-entry in 2026 is about proving residence, so treat every trip like an audit and keep your evidence ready before departure from the U.S., always. Issue 6 is the citizenship push, because policymakers and practical reality both signal that citizens have the strongest protection, and processing remains relatively fast now. For many green card holders, naturalization is the smartest move in 2026, because citizens cannot be denied entry and are not deportable in general, ever. But there is a catch. When you file N-400, USCIS re-examines your entire history, including how you obtained your green card in the first place. That means old marriage cases, old employment filings, or old misstatements can surface during citizenship review, even if your green card was issued years ago. If you received residency through marriage and later divorced, officers may ask for proof the relationship was real, so keep evidence and timelines organized now. If you have tax gaps, missed filings, or foreign account issues, fix them before applying, because tax compliance is part of good moral character review. If you have any arrests, even dismissed, obtain certified dispositions first, because N-400 questions cover arrests and citations, not only convictions for safety, always too. Citizenship can be a shield, but applying prematurely with unresolved issues can open risk, so treat N-400 as a serious audit of records in 2026. The good news is that clean cases still succeed, and many people naturalize smoothly when they prepare, disclose honestly, and bring documentation to interviews well. So do not avoid citizenship out of fear. Avoid it only until you are ready, because readiness turns scrutiny into routine approval for you today. Quiet point. Missed mail can destroy you, because USCIS denies cases as abandoned when you miss biometrics or interviews after address changes or delivery failures. Green card holders often move for work or rent, forget to file AR-11, and then never receive the notice that controls their legal timeline today. If you miss a biometrics appointment or an interview, USCIS can close the case, and reopening can take months or require refiling from scratch again. Even worse, a missed notice can create gaps in work authorization or travel documents, forcing people into emergency filings and risky status decisions under pressure. So update your address within 10 days, keep USPS forwarding, and create a USCIS online account to see notices even if mail fails sometimes too. Set calendar reminders for renewal windows, screenshot your case status, and save every notice PDF, because records protect you during disputes with agencies later on. If you sponsor family, check your email weekly, because NVC and consulates also send time-sensitive messages that can expire quickly without warning in 2026. This is why some people feel rights are taken. They are not arrested, they just miss deadlines, and the system moves on without them anyway. If you do everything right but lose a notice, you can still lose months, so treat mail management as immigration compliance starting today for real. That quiet habit, updating addresses and tracking notices, is one of the easiest ways to stay safe in 2026 without spending money on lawyers first. Let's summarize the 6 pressure points: financing barriers, public charge fear, overseas vetting delays, old record lookbacks, reentry scrutiny, and citizenship review risk in 2026. None of these mean you are helpless, but they do mean you must operate like a documented resident, not like someone hoping luck will hold. Start with records. Keep tax transcripts, leases, pay stubs, and travel logs, because documentation is what convinces officers and resolves disputes quickly for you today. Second, clean up your legal history. Get certified court dispositions, resolve warrants, and ask counsel before travel, because prevention is cheaper than detention every time. Third, treat borders like audits. Answer precisely, never guess dates, and carry proof that your life is in the United States, not abroad full-time. Fourth, if you need long travel, apply for a re-entry permit early, but still keep U.S. ties active and documented throughout your trip abroad too. Fifth, if you are eligible for citizenship, prepare intentionally. Review your green card history and file when you can answer every question confidently under oath. Sixth, manage mail like a security system. Update addresses, check accounts, and never miss appointments, because missed notices create preventable denials for you in 2026. If you follow these habits, you can still thrive as a green card holder, build a business, travel, and move towards citizenship safely this year. If this helped, subscribe to US Policy Brief, like the video, and comment with your situation so I can cover what matters most to you. Because the SBA topic is trending, I want to repeat a key safeguard. Do not rely on a TikTok deadline. Rely on the lender's policy. If a bank says a business must be 100% citizen-owned, ask whether that rule comes from SBA guidance or the bank's overlay. Then ask for alternatives. Some programs focus on lawful presence, some allow resident owners, and some require citizen guarantors rather than citizen equity alone sometimes. If you are applying near a policy change date, submit early, but do not misstate ownership, because misrepresentation on loan paperwork can become immigration trouble. Keep your business compliant, renew licenses, pay payroll taxes, and separate personal and business accounts, because strong compliance improves both lending and immigration credibility today. If you plan to sponsor workers or file your own naturalization, financial records matter, so keep bookkeeping organized and avoid cash practices that create questions. For partnerships, document who controls decisions, who signs for loans, and who receives profits, because control and ownership are not always the same legally either. If you restructure for legitimate reasons, write down those reasons, because later you may need to explain why ownership changed during immigration review or audits. If you are a new resident entrepreneur, build credit early, because the safest strategy is not one loan, but multiple healthy options over time anyway. Green card holders contribute massively to local economies, so if you feel targeted, remember the best response is compliance, documentation, and smart alternatives in 2026. On travel, know your rights. A lawful permanent resident has a right to seek admission, but CBP can inspect, question, and delay entry for review. Delays are stressful, but they are often used to gather facts, so staying calm and consistent protects you more than arguing with officers there today. If an officer suggests you abandon residency, do not sign Form I-407 unless you fully understand it, because it is voluntary surrender of status forever. You can request to speak to an attorney, and you can ask for immigration judge review, although that choice may involve detention or paperwork later. If you travel to a region under heightened scrutiny, expect secondary inspection, and keep extra time between flights because missed connections are common in 2026. When asked about your trip, explain purpose, length, and return plan in one sentence, then offer documents instead of oversharing details under stress at all. Phone searches are controversial, but if you carry sensitive data, assume it could be viewed and avoid storing anything false or misleading on devices today. Refusing to unlock may be a right, but it can prolong inspection, so decide your approach in advance and keep your content clean for travel. Remember, most green card holders enter without issues, so the purpose of this warning is preparation, not fear or drama for you in 2026 alone. If you have questions about your travel risk, post them in the comments and I will cover the most common patterns in future episodes here. By now you can see the pattern. The government is not erasing green cards, but systems are tightening and mistakes are punished faster in 2026. That means you protect yourself by acting early, verifying rules, and keeping your record clean, rather than trusting rumors or reacting late every time today. If you own a business, treat financing eligibility like homework and confirm it with written lender guidance before you restructure ownership or miss deadlines again. If you travel, plan buffers, carry your ties, and never guess in interviews, because border officers are trained to detect inconsistencies quickly in 2026 now. If you are considering citizenship, prepare the file like an audit, review taxes and arrests, and file only when your history is consistent and complete. If you are applying from abroad, focus on clean NVC submissions, respond fast, and expect vetting delays in some cases without assuming denial immediately either. And if you do nothing else, manage your address and mail, because missed notices create the easiest, most preventable disasters for immigrants in 2026 today. I know these topics feel heavy, but information is power, and most green card holders who plan carefully will be fine and stable this year. If you want calm weekly updates, subscribe to US Policy Brief. And if you found value, like and share it with one person today, please. Drop your question in the comments, and I will answer with facts, sources, and practical steps, because you deserve clarity in 2026 about green cards.